2017 was really a change year. Following the federal election of 2016, we've had a change of administration that's led to changes in personnel in the courts, in the agencies. We've seen a reorientation of federal policy away from moving in a pro-worker direction as it had during the previous administration to now moving in a more pro-business direction, and that's likely to continue for the next several years. We've also seen the state and local governments get more active in the wage and hour space than they had in previous years. 2017 saw the Supreme Court take the case involving the enforceability of arbitration agreements with class action waivers. The status of those agreements has been in doubt over the past couple of years because of a perceived conflict, a potential conflict with the National Labor Relations Act, and we expect to see a decision on that issue in the coming months. Another area that was important in 2017 has been the federal 2016 overtime regulation that would double the salary threshold for the executive, administrative, and professional exemptions. The status of that regulation was in doubt following the 2016 election, and in 2017, the Trump administration has pulled back on that regulation, and now they're going in a new direction, and we expect to see a new regulation in the coming months. So a third area of change has been federal enforcement policy in the wage and hour space. The Department of Labor has withdrawn important guidance documents from the Obama administration on the issue of joint employment and independent contractor misclassification, and that's led to uncertainty and hope, perhaps, among the employer community about the breadth and reach of federal employment laws, particularly the Fair Labor Standards Act. These actions have caused employers to have uncertainty about where the law is. They know where the law was going, and I think they have a sense of where the law may be going after a few years of the current administration. But in the meantime, it's left employers in limbo because a lot of these major issues are unsettled. They're up in the air. We have the Supreme Court with the arbitration case. We have the Department of Labor mulling now what it's going to do over the overtime standards. The Department of Labor is still in the process of sorting out who's going to be running the agencies and what their positions are going to be on key issues. And we're also seeing uncertainty with regard to what the state and local governments are going to do as they start to step into the breach. So employers now are waiting for the dust to settle. In 2018, I think employers are going to get some answers to a number of the questions that were raised in 2017. We're going to see a decision from the Supreme Court on the enforceability of these class waivers and arbitration agreements. We will get clarity, almost certainly, on the issue of what will be the salary threshold for the executive, administrative, and professional exemptions. And then we're also going to see where exactly is the Department of Labor going in its enforcement policy in terms of how it handles investigations, imposes penalties, seeks liquidated damages, and that sort of thing. So we're going to see more guidance about where the department will be in its enforcement.